So we've looked at the First Amendment. We know that the First Amendment protects our freedom of speech and our freedom of press, but those are really vague. It's just like, okay, what is the freedom of speech? So how is it that I'm protected by what I say? So the only way that we know is if we look at the Supreme Court cases that have already gone before us, because the Supreme Court is that check and balance in the government, and they take the Constitution and they say, okay, it says this, and this is how we see, this is what it means. This is how we interpret it. So, excuse me a moment while I move myself out of the way to present it. This is looking at just a couple of really important, I can't make myself any smaller, but I just want to take a moment and look at 5 really significant Supreme Court cases that we have to look at and remember, so we know, okay, what is the limitation of free speech and what can we do? So Shank versus United States. This was in 1919. Basically, there were 2 socialists who didn't agree with the fact that the draft had been instated for World War I, and they were distributing pamphlets telling people, hey, don't go if you're conscripted. Don't join the draft. They were arrested and charged with what was called conspiracy to violate, there's a specific act, the Espionage Act of 1917. And they were saying basically that their pamphlets were designed to cause distress and kind of interrupt the operations of the army, essentially. They went the whole way up to the Supreme Court. They kept fighting it. And the Supreme Court actually said that their actions were not protected. So we do have the right of speech where we cannot be arrested for speaking out against the government. But they said that during wartime, these specific pamphlets created what was called a clear and present danger. So basically they were like, hey, we are in a serious time right now. If you disrupt our ability to conscript people into the army, you are putting the nation at risk. And so they actually, their conviction was upheld. For better or worse, the government can state, hey, it's a clear and present danger that you are saying these things, even if you feel like you are presenting your freedom of speech. Next one, Tinker versus Des Moines. So this one is specific to schools. This was back during the Vietnam War in 1968 is actually when this happened. In 1969 was when it made it up to the Supreme Court. But essentially, a group of students wanted to protest the Vietnam War, and so they wanted to wear black armbands around their arms. Principal found out, didn't want to bring politics into school, and they preemptively made a policy that said you cannot protest using like your physical armband. You can't wear an armband or you'll have to remove it or you'll be suspended. Students wore it anyway. They were suspended, and their parents sued because they said it was against their free speech. The children's actions, like the students' actions, were actually protected by the First Amendment. It did not interfere with the way the school was running. It did not make a verbal statement. It was not disruptive. And so the specific thing that you want to pay attention to is that students don't lose their freedom of speech when they step on school grounds. So you still have your own freedom of speech. Now, there's a little caveat to that in a minute, and we'll talk about it, but you can't disrupt or put people at danger in the school building, but you can still speak out about what you believe in, okay? Bethel School District 43 versus Frazier. So this is what I was talking about. We have to kind of step back for a little bit. There was school assembly, and a student named Matthew Frazier was making a speech at a school collection at the whole school, and he used vulgar language. All that they will say in the court documents is that he used a phrase that was interpreted to be a graphic sexual metaphor during his speech. Obviously, teachers were not okay with that. He was suspended for 2 days, but he actually sued and it went through the courts. His actions were not protected by the First Amendment. Essentially, they stated that lewd speech can be forbidden in school buildings because it goes against what they call the fundamental values. So it is a public building in a school, but there is still the expectation of appropriate language. So yes, you can be suspended and you can get in trouble for saying inappropriate things. Your freedom of speech does not protect you from those repercussions. It just means that if you wish to say something political or you wish to say something, you cannot be punished because you spoke your opinion. Does that make sense? You still have to be appropriate and you still have to be polite and you have to have a sense of decorum, but that does not mean you have to change your opinion. Next, we have the Hazelwood School District versus Colmier. You'll notice I'm pulling a lot of school ones because these are the ones that are going to affect you, this one in particular. At Hazelwood East High School back in 1988, the principal received edits and proofs of the school newspaper. And he said, I don't really like these 2 articles. I don't think they're appropriate. You got to pull them. You can't post them. And former students and one of the current students actually took him to court. But the principal is allowed to say you cannot publish those things because it is a school-sponsored newspaper. Again, we are a school-sponsored broadcast journalism class. So if an administrator or if I say, hey, we can't publish this piece the way it is, or if we go to Dr. Holt and say, hey, can we publish this? And he has concerns, we cannot publish it anyway. You cannot publish it anyway. You will be up for repercussions. Okay, that's so important to know. We are a school publication, and so we have to follow the school expectations. All right. Essentially, the quote here is that it has to be a concern for educational purposes. So they can't just say, oh, you're saying that I did this thing bad. No, you can't post it. It has to be, hey, if you post this, it will be disruptive to the educational kind of curriculum or community that we have built. And then lastly,
Marvin Hamlet to the main office, please. Marvin Hamlet to the main office, please.
Apologies. Lastly, we have Texas versus Johnson in 1989. And this one is a big contestant. You can either agree with this or you can disagree with this, but this is the last time that the Supreme Court spoke on this issue. Gregory Johnson burned an American flag in front of Dallas City Hall. There was a Texas law that said you cannot desecrate the flag. He was arrested. But he contested the law and got the whole way up to the Supreme Court, and his actions were protected. They said, no, he has the right to burn the flag because it was a modicum of freedom of speech, and that you don't have the ability as a government to say, hey, this specific symbol can only be used this one way. And this is the really big important quote that came from this. And this is the main reason that I pulled this one for us to study, is this quote right here. If there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. Take a moment, let that sink in. Just because something is offensive does not mean that it is not protected by free speech. So you can say something and you can offend people and you are technically protected by free speech, but it does not prevent you from having repercussions in the public sphere. It just means you cannot be arrested for it. So I can go out there and say, this government official is terrible and they're doing this horrible thing, and I'm going to symbolically, make this protest, and I can get in trouble for it for speaking out as a teacher, because in my position, I could maybe be seen as promoting that within students. I could maybe get in trouble, with my family or with my local community. I could definitely see repercussions from those around me if everybody else agrees. But I cannot be arrested for it unless I am actively threatening that person, or I am actively disrupting the peace and threatening the people around me during my protest. Okay? So there is a limitation on you cannot threaten people and you cannot cause a massive disruption. You can be arrested for those things, but you cannot simply be arrested for saying something that people disagree with. Okay, that is the main reason. I know burning a flag can be a really touchy subject, but the desecration of the flag as an action is still technically protected by free speech. There would have to be a threat involved for you to see legal government trouble. Okay. Now, I want you to go through each of those and memorize them as best as you can. I am not looking for you to memorize this whole paragraph. Okay, I gave you this paragraph so that it kind of goes into the specifics. All you really need to memorize, if it helps you, is Tinker versus Des Moines, armbands allowed in school. Okay, that's how I would memorize it. And that's where it's like, okay, Tinker versus Des Moines, you can wear an armband in school and protest. That is protected by freedom of speech. That's all I'm looking for, okay? You are going to have a quiz on these. It is just going to be matching and true false. I am not trying to trip you up. I am not going to make you write word for word what each of these is. I'm not even going to make you memorize exactly which it's going to be, where I say, which one was about burning the flag, and you have to tell me the title. I'm going to give you the title. I'm going to give you what they said. I just need you to connect them, okay? Please don't panic. But you have to be able to understand and explain the limitations of freedom of speech, especially as it pertains to a school production.